Welcome to this comprehensive overview of employment law in the United Kingdom. Whether you're an employer, manager, human resources professional, or employee, understanding the legal framework that governs workplace relationships is essential for creating fair, productive, and legally compliant workplaces. This presentation aims to guide you through the complex landscape of UK employment legislation, highlighting both rights and responsibilities that affect all participants in the employment relationship. We'll explore key aspects from contracts and working time to discrimination protections and emerging trends. UK employment law operates under both statutory provisions enacted by Parliament and common law principles developed through judicial decisions, creating a comprehensive system of workplace regulation. The Employment Rights Act 1996 serves as the cornerstone of modern employment protections, establishing basic rights from unfair dismissal to redundancy pay. Employment tribunals handle over 250,000 disputes annually, providing a dedicated forum for workplace-related claims outside the ordinary court system. Despite leaving the EU, the UK has retained many employment protections derived from European law through the mechanism of retained EU law. The evolution of employment law in the UK has been shaped by significant historical events. During the Industrial Revolution, early factory acts began to limit child labour and establish basic safety standards. The late 19th and early 20th centuries saw the rise of trade unions and collective bargaining, leading to gradual improvements in working conditions and the recognition of worker rights. The European Union's influence from 1973 to 2020 significantly expanded workplace protections, particularly regarding equality and collective redundancies. The modern framework, consolidated by the Equality Act 2010, represents the culmination of decades of progressive development toward comprehensive workplace protections. The British employment law system draws from multiple sources that work together to create a comprehensive framework. Primary legislation provides the foundation, while secondary legislation adds necessary detail. Case law interprets these statutes and applies them to specific situations, creating binding precedents. Advisory bodies like ACAS and the Equality and Human Rights Commission provide authoritative guidance through codes of practice, which tribunals must consider when making decisions. Effective agreements between employers and unions can establish terms and conditions that become legally binding. Employment status in the UK is categorised into several types, each with distinct rights and protections. Employees work under a contract of service with full statutory protections, including unfair dismissal rights and redundancy pay. Workers have mid-tier status with some protections, such as minimum wage and working time rights. Self-employed individuals operate as independent businesses with minimal statutory protections. The gig economy, characterised by flexible on-demand work, has prompted legal challenges to redefine some workers' status, particularly in the context of companies like Uber and Deliveroo. Employment contracts contain both express terms, which are explicitly stated, and implied terms, which are automatically incorporated through custom, practice, or law. Certain statutory rights form an immutable foundation that cannot be contracted away, ensuring that the written agreement states the full range of rights and obligations. Since April 2020, employers must provide a written statement of particulars on or before the first day of employment, detailing key terms including pay, hours, and holiday entitlement. Special protections exist for 0 hours and part-time workers to ensure they receive proportionate benefits. The Working Time Regulations 1998 establish a 48-hour limit on average weekly working time, calculated over a reference period. However, adult workers can voluntarily opt out of this limit by signing a written agreement. Rest periods are essential, with workers entitled to minimum daily and weekly rest periods and a 20-minute break when working more than 6 hours. Annual leave entitlements ensure all workers have the right to 5.6 weeks of paid leave per year, which can include bank holidays, but employers cannot substitute payment for leave except upon termination of employment. The National Minimum Wage Framework establishes minimum hourly rates for workers, with the highest rate, the National Living Wage, applying to workers aged 23 and above. Gender pay gap reporting is mandatory for employers with 250 or more employees, highlighting average hourly earnings of men and women across key work groups. Equal pay legislation mandates that men and women must receive equal pay for equal work or work of equal value, and employers must publish annual reports on their gender pay gaps, creating transparency and encouraging action to address disparities. The Equality Act 2010 consolidated previous anti-discrimination legislation into a single comprehensive framework. It protects individuals from less favourable treatment based on 9 protected characteristics throughout the employment relationship. Direct discrimination occurs when someone is treated less favourably because of a protected characteristic, while indirect discrimination happens when an apparently neutral policy disproportionately disadvantages people with a particular protected characteristic. Employers have an additional duty to make reasonable adjustments to remove barriers that put disabled employees at a disadvantage. Family-friendly rights in the workplace are designed to support employees with family responsibilities. Maternity rights ensure pregnant employees are entitled to 52 weeks of maternity leave, with statutory pay available for up to 39 weeks. Paternity and shared leave allow new fathers to take up to 50 weeks of leave, with shared parental leave offering flexibility for parents to split childcare responsibilities. Additional entitlements include the right to request flexible working arrangements and unpaid parental leave, supporting a better work-life balance for employees with family commitments. The Health and Safety at Work Act 1974 establishes the fundamental principle that employers must ensure, so far as reasonably practicable, the health, safety and welfare of all employees and others affected by their operations. Employers must conduct suitable risk assessments and implement appropriate preventative measures. When risks cannot be adequately controlled, employers must provide appropriate personal protective equipment free of charge. Employees have a duty to cooperate with employers on health and safety matters, creating a collaborative approach to workplace safety. For a dismissal to be fair, employers must demonstrate both a fair reason and fair procedure. The 5 potentially fair reasons are conduct, capability, redundancy, statutory restriction, or some other substantial reason. Many employees need 2 years' service to claim unfair dismissal, though certain dismissals are automatically unfair regardless of service length. Automatically unfair reasons include dismissals related to pregnancy, whistleblowing, asserting a statutory right, or union activities. These require no qualifying period and can lead to higher compensation awards. A genuine redundancy situation must involve the cessation or diminishment of the requirement for employees to perform work of a particular kind. Employers must consult with affected employees or their representatives, with specific criteria for selection that are objective and non-discriminatory. Statutory redundancy pay is available for employees with at least 2 years' service, with many employers offering enhanced redundancy packages beyond the statutory minimum. Consultation should seek to avoid redundancies and mitigate consequences, ensuring a fair process. The AKS Code of Practice on Disciplinary and Grievance Procedures provides essential guidance that tribunals consider when assessing procedural fairness. Employers must conduct a reasonable investigation, provide advance notice of allegations, and allow the employee to present their case and offer a right of appeal. Failure to follow the code can result in up to a 25% increase in compensation if the employer is at fault. These procedures ensure employees can raise concerns and have them addressed properly through a structured process. The transfer of undertakings, protection of employment. Regulations protect employees when a business or service provision changes hands. Employees automatically transfer to the new employer with their existing terms and conditions intact. This principle applies to both business transfers and service provision changes, ensuring workforce stability during organisational changes. Dismissals connected to the transfer are automatically unfair unless there's an economic, technical, or organisational reason entailing changes in the workforce. The Public Interest Disclosure Act 1998 provides robust protection for employees who report wrongdoing. To qualify for protection, disclosures must relate to certain types of wrongdoing, such as criminal offences or dangers to health and safety, and the whistleblower must reasonably believe the disclosure is in the public interest. Protected whistleblowers cannot be subjected to detrimental treatment or dismissal. When internal disclosures are generally ineffective, external disclosures to regulators or even the media may be protected in certain circumstances. The UK GDPR and the Data Protection Act 2018 establish principles for processing personal data, requiring it to be lawful, fair, transparent, purpose-limited, accurate and securely stored. Employees have rights to be informed about data processing, access their data, and object to certain processing activities. Employers must justify monitoring practices and ensure proportionality between business needs and privacy intrusion. Effective record management is essential, with employers required to report data breaches to the Information Commissioner's Office within 72 hours. Qualifying employees can receive statutory sick pay for up to 28 weeks when they're too ill to work. For absences of 7 days or less, self-certification is sufficient, while longer periods require a fit note from a healthcare professional. Long-term health conditions may constitute disabilities under the Equality Act, triggering the employer's duty to make reasonable adjustments. This might include modified equipment, altered working hours, or phased returns after absence, ensuring employees are supported in their return to work. Under the Equality Act, harassment is unwanted conduct related to a protected characteristic that violates a person's dignity or creates an intimidating, hostile, degrading, humiliating, or offensive environment. Employers can be vicariously liable for harassment committed by their employees unless they can demonstrate taking all reasonable steps to prevent such behaviour. Effective anti-harassment measures include clear policies, regular training, and accessible reporting procedures. Creating a speak-up culture is essential for early intervention, with government proposals for a proactive duty on employers to take preventative measures. The Modern Slavery Act 2015 requires commercial organisations with a global turnover of £36 million or more to publish an annual statement detailing steps taken to ensure their business and supply chains are free from modern slavery and human trafficking. This statement must be approved by the Board of Directors and signed by a director or equivalent. Beyond compliance, organisations face increasing stakeholder pressure to demonstrate meaningful action rather than superficial box-ticking. Failure to comply can result in injunctions and significant reputational damage. As the workplace evolves, remote and hybrid work models are becoming increasingly prevalent. Employers are tasked with ensuring health and safety for remote workers, which includes conducting risk assessments and providing necessary equipment. Hybrid models require careful planning to avoid discrimination, ensuring equal opportunities regardless of location. Additionally, the right to disconnect is gaining traction, allowing employees to separate work from personal time. In today's digital age, the line between personal and professional conduct online is blurring. Employers can take disciplinary action for social media posts that harm the company or colleagues. Clear social media policies are crucial, balancing employee privacy with company interests. Employers must also comply with data protection laws when monitoring employees, ensuring actions are justified and proportionate. Employment tribunals offer a formal avenue for resolving workplace disputes. The process begins with lodging a claim, followed by a pre-hearing process involving document exchange and witness statements. Tribunal hearings involve formal proceedings with evidence and cross-examination. These tribunals are designed to be accessible, providing a fair resolution to workplace disputes. Settlement agreements provide a legally binding way to resolve workplace disputes, often involving compensation. They must meet specific legal requirements and typically include terms like financial compensation and confidentiality clauses. Tax considerations are also important, as certain payments may be tax-free. Legal advice is crucial to ensure the agreement is fair and compliant. Trade unions play a vital role in representing employees, offering recognition for collective bargaining and protection for union representatives. Industrial action requires a properly conducted ballot, and recent legislation has increased thresholds for such actions. Beyond union rights, employers must engage in information and consultation processes, especially during significant workplace changes. Brexit has brought significant changes to employment law, affecting regulations on working time, agency workers, and family leave. While some rights have been retained, others are under review, potentially leading to modifications. Employers must stay informed about these changes to ensure compliance and protect employee rights. The landscape of employment law is shifting with emerging trends like AI in recruitment, compressed working hours, and menopause awareness. AI is transforming hiring processes, while 4-day workweeks are gaining traction. Menopause is increasingly recognized as a workplace issue, and climate activism is raising questions about employee rights. Staying informed on these trends is crucial for compliance. To ensure compliance with employment law, regular policy reviews and documentation systems are essential. Management training on discrimination and harassment is crucial, along with seeking external expertise for complex legal issues. These practices help mitigate risks and ensure a fair and compliant workplace environment. Numerous resources are available to support both employers and employees in navigating employment law. ATS provides free advice and a helpline, while Citizens Advice offers guidance through local branches and online resources. Law Centres Network offers legal representation and support, ensuring access to justice for those who need it most. Effective employment law compliance requires a solid foundation of statutory obligations, robust documentation, and proactive management. Building a positive workplace culture based on respect and continuously adapting to legal changes are crucial. These key takeaways ensure compliance and foster a fair workplace environment.